On January 10, 2025, defendant Michael Darrell Jones was indicted by Harris County Criminal Court in Texas for interference with public duties. According to the peace officer Aaron Marican, Mr. Jones was initially committing a criminal trespass, aggressively screaming to a resident in a residence, and later became an interference with public duties. Under Article 30.05 of the Texas Penal Code, a person commits criminal trespass if they don't have permission to be on the property and they knew they were not supposed to enter, or were asked to leave. Mr. Jones was pleading for a probable cause in Judge Fletcher's courtroom.
My client is Michael Jones, and he's in custody, and he's asked me to argue probable cause for him, and so I
Sure,
shall.
of course. You ready?
Yes, Judge. Does he need to be brought out, or do you, I don't know your process.
Mr. Jones, please. Yeah, it's only fair, right? Because it's his case, so
You didn't hear me.
it's only fair because it's his case, so we might as well bring it up.
No, he asked me to do this, and so I told him I would. Yes, Michael Jones.
Okay,
That's my client.
he must be unhappy.
Asked him to breathe.
Or
Asked
hungry.
him to breathe.
You said Jones, right? Michael
Yes,
Jones?
Judge. Michael Jones, 254-6980.
Judge, hold on, before you leave, there's an attorney that's in the waiting room.
Okay. Ms. Beck? Celine Beck?
Yes.
Okay. Oh, yeah, I haven't seen her in a long time. Good morning. How are you?
Hey, buddy.
If you're banging on the door, you got to be careful because you break something, you're gonna catch another charge. So be careful banging on those windows because they break very easily. All right. So you were Michael Jones. Mr. Jones, we're talking about you, so that's why I wanted to bring you out. It's only fair that you get to hear what's going on with your case. Your lawyer wants to challenge probable cause in this case. You're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. That's what you're charged with. I don't know. So I'm gonna have them read, and we're gonna do probable cause to see whether we're gonna go forward or not. Okay? Okay. What happened?
On January 10th, 2025, the officers in official uniforms and riding in a marked patrol vehicle were dispatched to a disturbance at a residence in Harris County, Texas. The officer observed the defendant standing outside the location, being told to leave by the resident, to which the defendant refused by verbally yelling at the resident in a loud, aggressive tone of voice. The officer announced themselves and observed the defendant begin to walk away. The officer gave the defendant a verbal command to put his hands behind his back, and the defendant pulled his hand away. The defendant refused to comply with verbal commands, and the defendant held his arms to his chest as the officer attempted to detain him. The defendant continued to refuse additional commands to stop resisting and put hands behind his back. He yelled at the officer in an aggressive tone and shouted out loud, "Don't let them take me." The officer performed a leg sweep and continued to struggle handcuffing the defendant due to him pulling away. The officer began to roll around while on the ground and reached the officer's hands to prevent him from being placed in handcuffs. The officer continued to give commands, and the defendant continued to refuse.
I get it. But what's he doing? I mean, he's walking away. That's what they wanted, right?
So,
No?
Just losing?
so, Your Honor, in this case, to read the full dim, it was the disturbance call, and they said they observed him standing outside the above location, being told to leave, and they observed him verbally refuse, and then
Right, but then cops get up there.
and then they observed him begin to walk away. And it says they approached Jones and observed he was intoxicated in a public place based on his slurred speech, pupil size, and
Didn't say that.
That was in the complete dims, Your Honor. And then it
Do you know
says.
about that?
Yes, Judge, but
Go
my
ahead.
argument prepared. Judge, my argument is exactly what you started to say. There's some sort of disturbance. Somebody's asking him to leave. They're yelling and screaming at each other. Police coming up and saying, "Hey, I'm the police." You can walk away from that all day long. My client did walk away from that. My client's loud and emotional, as you can tell here today. You're allowed to walk away emotional, yelling, screaming, even using profanity in this state if you want to. Then the cops come up to him and suddenly there's some kind of unfounded allegation of intoxication. There's absolutely no facts other than that statement, "I smell marijuana, you look intoxicated," because it looks like he walked away and the cops didn't want him to walk away. And so now they need a reason to arrest him. My argument is based on if he's charged with interference with a public servant, that doesn't come until later. He has to be lawfully arrested and lawfully detained or lawfully with the police before that even occurs. Walking away when a resident tells you to leave and all you've got in your sworn statement is, "We identified ourselves as police," so what? Everything that happens after that is fruit of the poisonous tree.
So they go up and they see that he possibly could be intoxicated. So does it go into a potential public intox investigation.
If it does, they need to announce that. You can't just walk up to me and say, I'm the police, stop. We don't live in that kind of society. I'm the police, I need to investigate you, so therefore stop all day long. I'm the police, we're investigating, I need you to step aside, sir, so I can investigate this matter all day long. But hey,
So-
I'm the popo.
So the reasonable suspicion we have is they begin to investigate what?
So
A criminal trespass.
they're called, yes, a disturbance, and they saw him yelling, being aggressive, and then as he walked away, that's when they saw.
So
signs.
the trespass investigation ceases because he's leaving,
Right.
yes or no?
It's not specified to be a trespass, Your Honor, it's specified just to be a disturbance.
That's what it is. Okay, but it's a trespass that they're investigating a trespass, right? I mean, for all intents and purposes, isn't that what it is?
According to Mr. Jones's attorney, Ms. Tichy, the police had no legal basis to make the arrest of Mr. Jones. Under Article 38.15 of the Texas Code of Criminal Procedure, a person who commits an offense and makes a police officer performing a duty or exercising authority imposed or granted by law. Ms. Tichy's argument is that the officers had no legal basis to stop Mr. Jones. Even if Mr. Jones had used profanity directly to the peace officers, it would also not be a crime on any matters. In general, peace officers have the authority to control simple movements of a person, such as to back up or stop a vehicle without explanation. Usually when a peace officer explains why they are investigating a person, it is easier for people to cooperate, and later, to make the case for a judge to see the sequence of the timeline of the events. But the peace officer needs reasonable articulable suspicion in order to an investigatory detention. Otherwise, the case can be dismissed.
The investigation begins as a trespass investigation because he's there. Homeowners asked him to leave. He's refused to leave. So cops come and he begins to leave. So at that point, all should have ceased. But the cops go up to try to.
Well, in this case, Your Honor, it would be that, yes, he attempted to leave, but once the officers arrived, so they would still need to investigate to determine if the trespass even occurred, to determine,
He's leaving.
He's walking.
He's leaving, right? It's like, here, let me come and mess with you more,
That would only.
right? So it's like adding fuel to a fire.
But they would still have grounds to investigate, and furthermore, with the further signs of possible public intoxication, it would give them further grounds to investigate.
That's because they're going up to him to mess with him.
Well, they're going up to investigate what they saw, him refusing to leave, and
He leaves.
he only left once they arrived. So with maybe potential fear of apprehension, that's when he decided to leave, which it wouldn't undercut their ability to investigate what they had observed happen in front of them regarding that public or that disturbance that they were called about. They still need to figure out what happened there and if there was a trespass to begin with.
Judge, you can't flee a trespass. The way you comply is by fleeing.
Well, we don't know if it was a trespass, it was a disturbance. We don't always specify the disturbance.
I'm gonna find no probable cause. Mr. Jones, be careful, man. We have enough drama in this life, don't we? You don't like to wear orange, do you? Be careful where you go. Be careful what you do. Everyone's always out to get you, man. Don't let them. All right, man. Good luck.
After the officers saw Mr. Jones walking away from the residence, they attempted to charge the defendant with public intoxication. A public intoxication is not defined by having ingested alcohol in a public place, but when a person appears in a public place while intoxicated to the degree that the person may endanger the person or another. Seeing that the police officers tried 3 different reasons with a lack of cause to detain Mr. Jones, Judge Fletcher found no probable cause. The second case we are going to see was held in the courtroom of Judge Kristen Simmons in the 54A District Court in Lansing, Michigan. On May 4, 2025, defendant Jiquane Walker was charged with assault, resistance, and obstructing police officers in violation of Section 750.81d of the Michigan Compiled Laws, a felony offense, and a misdemeanor of open intoxicant in a vehicle. On May 5th, Mr. Walker was released on a $2,000 bond. The court set a probable cause conference on June 17th.
On the record in the matter of the state of Michigan versus Jaquane Walker, 25-01309, appearance, please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
Good morning, Your Honor. Attorney John Abbott with the Public Defender's Office representing Mr. Walker. He's standing here next.
Okay, Mr. Walker was scheduled for a preliminary examination today. I'm looking at the notes here. It looks like the offer previously was an Open alcohol container. No, open alcohol, open container in vehicle, 90 days with HIDA. That was the previous offer, but there was a different offer today, correct?
It was, Your Honor,
Which was,
any misdemeanor we could think of with HRPA, and I thought of trespassing.
okay,
Rejected that offer, and we were ready to proceed with the preliminary.
okay, that's what you want to do, sir? Is that a yes? Okay, you can call your witness.
Okay, Your Honor. The people would call Damon over to the stand.
Solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, Your Honor.
Thank you.
So how did your interaction with Mr. Walker proceed?
Yeah, so when I went into the parking lot, a big area of concern was that, again, people were in this parking lot, and at that time, it was around 1 o'clock, later than 1 o'clock at night, just far past park hours being closed.
When you say 1 o'clock at night, you mean 1 a.m.?
Yes, yeah,
Awesome.
1 a.m., sorry.
No, that's okay. Just want to clarify for the record.
So 1 o'clock in the morning, I apologize. Which in the city of Lansing, there is a local ordinance that prohibits people and vehicles from being in parks and parking lots associated with those parks. So there was a civil infraction occurring in my presence, so I went up to the vehicle.
Objection, Your Honor. So we
Objection sustained.
You went up to the window and what occurred then?
So as I'm approaching the vehicle, I noticed that there was a sole occupant in the car that was in the front passenger seat. And I noticed what I would describe as a furtive movement reaching down towards the floorboard, that area. So as I went up to approach the car, I identified myself as a police officer and as.
Were you wearing your uniform?
Yes, I was.
Your fully marked LPD uniform?
Yes, ma'am.
Okay, and you were in a fully marked LPD police car at this time as well? Well, exited the,
Yeah, the police car was a little ways away. but
okay,
Was in the area.
okay.
So as I walked up to the car, I again identified myself and, let the occupant know why I was stopping and talking to him, and requested their identification.
Okay, and how did Mr. Walker respond to that?
Mr. Walker refused to provide his identification. When I first made contact with him, I asked him to roll the window down, but the car was not on, so he opened up the door slightly. When I told him he was being detained and that I needed his identification, he closed the door on me. I asked him several times to open up the car door again. He was not opening up the car door, and it just kind of led into an interaction where he was not responding to the commands I was asking for him to identify himself.
So how did you proceed?
So eventually, one of my partners was able to find an unlocked door from the vehicle and opened it up. And we began having further conversation with him that way, telling him that he needed to step out of the car and identify himself. Eventually, he did open up the car door more fully this time around, and I was able to see further into the car and noticed a open container of alcohol in the vehicle, which again was just a furtherance of more of a reason for contact and wanting to get him out of the car. So we asked him to step out of the car. He refused to do so, which eventually led to us having to put our hands on him to pull him out of the car, which he tensed up when I grabbed onto him and wasn't fully complying with the step out of it.
Okay, and were you wearing a body worn camera?
I was wearing it.
And if I showed you that body worn camera footage today, would you recognize it?
I would be able to recognize it, yes.
Okay.
Hey, what's going on, man? So we got
Everybody over here. I've been in this car this whole entire time since they've been in the party. I don't want to talk to you.
So hold on. Whoa. Hey. You're in a park after dark. I need you to identify yourself. So hold on. You are currently.
Why are you opening the door? So
Yeah, well.
Whoa,
You ain't listening. Listen. Hey, relax.
bro, hey, what's up?
You gotta relax for a second. You gotta relax for a second.
He can't do
Hey,
that.
I got my boss.
That's
Relax for a sec. Relax for a second, bro.
Bro, that is against
So we got two things going on here, right? I need you to listen to me for a second. Okay? So two things.
against the law.
No, I'll tell you.
Violating the law. I hope y'all know that. I hope y'all know that.
Can you listen to me?
I did not talk to y'all.
I was trying to figure out if they'll let you mute your thing and because I can hear the feedback over there.
Maybe.
No, here's the deal.
I'm not none of that.
Here's the deal. You are currently in a parking lot loitering.
Waiting on my
on top of that,
anything.
and then
I was
on
over
top,
there.
hold on, listen.
I was over there at the party. I
And then on
walked
top
over
of
here,
that,
and then
this
you
lot
all-
is associated with a park. It is a city lot,
You're
and
talking
you
to
are
everybody.
currently in
You're
a
talking-
park after dark, right?
You're talking
So
to
I
me,
need
but
you
you're
to
not
identify
everybody
yourself.
else.
I need you to identify yourself.
No, I do not need.
I do this one car at a time, man. You're the one car that I stopped so far. I promise you, I'm going to do it to everybody
Talk to
else.
everybody else.
I'm about to, but you're the first one.
Bro, everybody else is sitting in their car. I just got back to the car. Y'all, you know this. You just tried to talk to me 8 times.
So here's the deal. I need you to step out of the car, or else we're gonna have to use force on you.
Why? For what? What have I done?
I'm telling you.
What have I done? Am I a suspect?
You're in a park after dark and you're loitering in a public
Bro,
lot.
I'm in a park. Hold on, bro. Let me take off my because it was cold outside. Hold on. Y'all are tripping. I'm not gonna lie.
So at the end of the day, it's just an identify, make sure you are who you are. Maybe
What do I have
we
to
write you
identify
a
myself?
warning ticket for being in
Sir.
the park after dark,
Sir.
and that's it. Okay.
Yeah. And then there's also an open container of alcohol. Doesn't matter, you're next to it. I got 3 violations on you. Loitering, park after dark, and open container of alcohol. That's 3 violations.
Just go ahead and step out of the car, man. Step out, brother.
Hey, watch out, watch out, watch out, watch out. Y'all cannot do that at all. That is against the law. I like that. You're violating law and you're do not touch me. I'm getting out the car willingly and do not touch me at all.
Then
Do not touch me.
step out.
Do not let me walk over there.
No.
Walk. Yes,
You're
you're
good
carting me. I feel uncomfortable.
Stand up right now,
You don't
I'm gonna put my
understand.
hands on you. Stand up right now and put my hands on you.
Stand up right now. You're putting.
Yeah, absolutely.
I'm getting out of the car. I'm getting out of the car willingly. Get, bro,
Step
get
out.
away from me. Get away
Yeah.
from
Step out of the car.
me. I don't
Step
know.
out.
Okay, that's a lot.
Whoa, watch out, watch out, watch out. All right, first off, I'm too tall. First off, bro, let me, bro, let me. All right, bro, y'all doing too. I'm not forcing, bro. Watch out, bro. Watch out. Y'all are bugging. I'm not. No, I'm not.
Stop.
For what? What am I
You're
being
tensing
detained
up.
for? Bro, watch out, bro. I'm not being detained for nothing, bro. No, I've been fucking talking to y'all this whole time, bro. Watch out. I'm not, bro. Watch out. Hey, bro, somebody grab my cousin, bro. Bro, grab Tone. Tone in the party right now. Ask for Tone. Bro, ask for Tone in the party right now. Ask for Tone. No, what am I being detained for?
Right now, it's our no too.
Please.
You listen to our commands at all. We gave
I'm
you
not
no
listening to your commands, sir. You asked me when I was in the parking lot. Did y'all not just ask me to stop?
No further questions for this witness, Your Honor.
Thank you for being here. All right, so this parking lot at the Brinkley Fish Lair, the south end of the parking lot is abuts up to the,
That's correct.
and the north end of the parking lot opens on Cedar Chavez,
Yes.
Yeah, Turner Street,
Yes, sir.
and there's businesses open there. The Pizza Hut was open. The pizza,
At some points throughout the night, most of the businesses around there are closed, but the Surf Pizza around there was open.
yeah, and then also a little bit to the east, the Unicorn, that might have been open still.
Is that unicorn?
Is there?
There was. It's not open anymore.
Not open anymore. All right. So anyway, and there was a lot of cars in the parking lot,
There were, yeah,
and they were probably customers of the pizza place, but we don't know.
unknown, so,
But based on your analysis, every car in that lot was violating a law.
yeah.
If anybody was there, even though it was a city lot and there's businesses open on the street.
So since it's associated with a park, then yes.
By associated, you mean the south side of the parking lot. But
The signage has the park in front of the parking lot before you enter into it, so I would consider it that, yes.
all right.
You said the signage has the park where, and then I didn't hear what you said.
I'm sorry. So there is a sign that says Brennicky Fish Ladder at the east side parking lot entrance. It's like a big sign that kind of. points
Okay,
into
it says called the fish ladder, and so the fish ladder is considered a park?
Yes.
Okay.
Right, but there was no evidence from his behavior, or from anything you or any of the other officers observed, that he was actually in the park.
I didn't see him physically like in the grass of the park.
Right, he was in the car when he got
He was in the car in the parking lot, yes,
in the passenger seat.
in the passenger seat. Correct.
Okay. And I heard somebody, I guess, videos, and, as far as that ordinance goes regarding the park, it's a civil infraction, isn't it?
That is correct.
And also, there's a couple of points in there where he said, let me get out, I'll go over there, let me get out, I'll go over there. Do you remember him saying that?
I do remember him saying this.
And so he was willing to leave the park. If he had not wanted to leave the park, that would have been a misdemeanor, right?
That is correct.
So you thought he was guilty of the civil infraction of being in the parking lot after.
Yes, that was one of the infractions. Yes.
And the other infraction was
Loitering in a public lot and then the open container.
loitering. How many seconds do you have to sit in your car before you're loitering, you know?
I wouldn't say that I know the seconds. From when I reviewed my police report, I remember observing the car for about 4 minutes in the parking lot.
Okay, so he might have been there for 4 or 5 minutes. And in your mind, that was loitering?
In my eyes, sitting there not being there for an apparent reason, that would have been one of the reasons.
So waiting for the other guy to come out and get in the car and drive away wouldn't have been.
It could have. I mean, I don't.
So at this time, you mentioned there was lots of people leaving the pizza place and getting into cars.
It's my recollection.
And were they all being similarly ticketed for the civil infraction?
If I would have done the same thing with him, I would have moved on to the next car. So I would have done the same thing for everybody else in the parking lot.
So this one happens every night up there in the whole time?
Objection, Your Honor, relevant.
You're right.
Justice System.
And there looked like there was lots of policemen there.
There were, yes.
Can you give me an estimate of how many officers that responded?
That were responded out there. I don't know entirely. I remember there being around about 5 or 6 specifically in this interaction.
So 5 or 6 guys helped pull him out of the car and put him on the ground?
We never put him on the ground.
Oh, okay, so put him under arrest.
I don't specifically recall exactly how many, but it was
a group effort?
I would say, yes.
And so he was charged with it. You know what he's charged with?
Yes, we charged him with resisting, obstructing, and container.
Making nothing for you.
According to Officer Damon Pulver, Mr. Walker committed 3 infractions: loitering, park after dark, and open containers of alcohol at the time. It is illegal to be in a park in Lansing after hours, and it can result in being charged with criminal trespass or a violation of park rules, which can lead to a misdemeanor charge. Later in his deposition, he recognized that there would be a civil infraction on parking because the parking space was related to the business around, not the city itself. According to Section 257.674 of the Michigan compiled laws, prohibited parking is a civil infraction, not a criminal one, which should result in a ticket or citation, not an arrest. And Mr. Walker said that he would move the car in that case. After the examination of the prosecutor Haley Fortuna Gill, defense attorney Mr. Etheridge cross-examinates it. The sequence of the facts and the context matters on these types of accusations. Mr. Etheridge asked about the local establishments working at that hour and the fact that there were other cars parked at the local. This way, he could confirm that was a civil violation and see if Mr. Walker was the only person charged, meaning that was a reason to Mr. Walker be parked at the place and not being an infraction such as loitering in park after dark, to find no probable cause to Mr. Walker being questioned by the authorities. This strategy in a cross-examination has the intention to show the judge another perspective of the police intentions with the defendant.
So you originally believed that this might have been at most a civil infraction. What caused you to open his door?
So the first time or the second time, or just in general?
In general.
Okay. So the first time, when I asked him to roll his window down, he said that his window wasn't rolling down because the car wasn't on. So I can't recall if either I opened the door or he opened the door the first time around.
Okay. You can't recall? Could we refresh this recollection?
You are currently.
Why are you opening the door?
Yeah, well.
No,
You ain't. Okay, listen.
It does appear that someone else came behind and opened the door.
Yes.
Another officer. And you would have no clue why that officer opened the door.
I mean, I couldn't say.
I don't want you to speculate.
I wouldn't say as to why.
Okay. I redirect.
None, Your Honor.
Any recross based on my questions?
Okay.
Okay. Thank you. Thank you. You may be excused.
Thank you, ma'am. I've already signed.
Oh, you're good to go.
You can call your next witness.
People know other witnesses. Your Honor, after seeing the proofs today, based on the evidence that came forward, the people do not feel like we have enough to move forward with these charges. And the misdemeanor attached to this file also would be fruit of an unlawful seizure. So we would ask that that charge is dismissed as well.
Case dismissed.
Thank you, Your Honor.
Thank you. We'll get you a dismissal.
In the beginning of the hearing, Mr. Etheridge claims that the police trespassed during duty. Judge Simmons asked the police officer Pulver why he opened the door to confirm the trespass hypothesis. According to Section 750.552 of the Michigan compiled laws, trespassing is a violation of property of a land or premises of another without lawful authority to do so. For a police officer to enter someone's private property, it needs to have a warrant or an emergency, such as hot pursuit of a criminal suspect. In Mr. Walker's case, the entry can be deemed unlawful, potentially violating constitutional rights. After dismissing Mr. Pulver, Judge Simmons asked the prosecutor if they would proceed. Ms. Fortuna decided to enter the order of nolle prosequi. Judge Simmons dismissed the case. In both cases, we saw the importance of the facts and the timeline they occur. In this way, the judge can see if it seems to have a formulated and comprehensive cause, or if it has an unreasonable appearance just to prosecute the defendant. In these cases, we could see the police officers changing their direction 3 times to find probable cause to the arrest of the defendants. After analyzing it carefully and the arguments used by the attorneys, The judges had the conclusion of no probable cause. Let us know in the comments if there is any case or courtroom procedure that you would like to see in the future. And subscribe for more content to have a more informed society.